This is the one that got me at the Charvet. Yeah.
On a record in cause number 324160, the case is styled as State of Texas versus Cleavon Demetrius Buxton. Let the record reflect that Mr. Buxton is present in the courtroom with his attorneys. Sitting first chair is Attorney Corey Crenshaw. Sitting second chair is Attorney Jansen Bailey. We also have present the State Assistant District Attorney, and sitting first chair is Ms. Julie Maxey. Sitting second chair is Mr. Daniel Boyd. State, are you ready?
We're ready, Your Honor.
Defense, are you ready?
We're ready, Your Honor.
Okay. Mr. Bailey, would you please call in the jury?
Three on the back row and two on every other side from someone picture in front. Ladies, move down one each, please.
Somebody's going to be up in the middle.
Move down. There you go. Yes, ma'am.
Okay. You may be seated. Let the record reflect that all parties are here in court and the jury is now present in the courtroom. On yesterday, ladies and gentlemen of the jury, you were given the oath, and so therefore we will proceed with the presentment of the information. State, are you ready?
Yes, Your Honor.
Defense, are you ready?
Yes, Your Honor.
Okay. Ms. Maxey, you may read the information. Mr. Buxton, would you please stand?
In the name and by authority of the state of Texas comes now the undersigned Assistant Criminal District Attorney of Jefferson County, Texas, on behalf of the state of Texas, and presents in and to the County Court at Law of Jefferson County, Texas, that in Jefferson County, Texas, Cleavon Demetrius Buxton, hereafter styled the defendant, heretofore on or about June 29th, 2019, did then and there operate a motor vehicle in a public place in Jefferson County, Texas, whilst the said defendant was intoxicated. And it is further presented in and to said court that at the time of performing an analysis of a specimen of the defendant's blood, the analysis showed an alcohol concentration level of 0.15 or more against the peace and dignity of the state.
Mr. Buxton, how do you plead?
Not guilty.
Okay, you may be seated. At this time, State, do you have any witnesses that, is there witnesses that you would like to present in a group to give the oath to, or we'll give the oath one at a time as they come in?
If we can do it one at a time, Your Honor.
Okay.
The defense will invoke the rule. I know they can stay for opening, but we would like to do that. I don't know if the court wants to do that now or.
Okay, is any witnesses in here?
No.
No witnesses, okay, and so we'll do that once they come in. State, do you wish to make an opening statement?
Yes, Your Honor.
You may proceed.
Good afternoon, ladies and gentlemen of the jury. I'm so grateful that you're here with us this afternoon to see that justice is done in this case. And I want to thank you for your willingness to serve on this jury. In the early morning hours of June 29th, 2019, sheriff's deputies were dispatched to Old Sour Lake Road. And that was in response to a suspicious vehicle parked in the middle of the road with 2 occupants. As deputies carefully approached the vehicle, the occupants weren't responding to the sheriff's deputies' commands. Eventually, the deputies realized that the occupants were passed out. The defendant was found in the driver's seat of the car with the car running, passed out behind the wheel. You'll hear from the sheriff's deputies that were dispatched to the scene. You're going to hear about their interactions with the defendant and how the deputies came to believe that he was intoxicated while operating a motor vehicle in a public place. You're also going to hear from the medical professionals who dealt with the blood evidence in this case, how they tested the blood evidence and what the results were. You'll see video today of the defendant behind the wheel of the running vehicle. You'll see for yourselves that the defendant was disoriented and displaying signs of intoxication. You'll also see the actual blood evidence from the night or the early morning in question. Ladies and gentlemen, it was discussed yesterday that the state has a high burden to meet in each element of this case. And I know that that's something that none of us in here take lightly. I encourage you to remember the elements that it's my duty to prove beyond a reasonable doubt that the vehicle was, that the person operated a motor vehicle in a public place while intoxicated. And remember to use your common sense and listen to what you hear in this courtroom and check in your gut if it makes sense. After all the evidence has been presented, you'll find that the defendant operated a motor vehicle in a public place while intoxicated beyond a reasonable doubt. We humbly ask that you would find the defendant guilty. Thank you.
Defense, would you like to make an open statement or would you like to waive or reserve your statement?
We'll reserve at this time, Your Honor.
Okay, you may be seated. State, are you ready to go forward?
Yes, Your Honor.
Okay. You can call your first witness.
Your Honor, the state calls Deputy Garrett Burdine to the stand.
Deputy Burdine, would you please come forward? The court reporter will swear you in. Would you please raise your right hand?
Do you solemnly swear that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
Okay. Deputy Burdine, you may have a seat in the witness stand and you can adjust the mic. and the chair.
We got drainage, G-A-R-Y. G-A-R-Y.
No, it's G-A-R-E-T-T.
Yeah. Okay.
Madam Prosecutor, you may proceed.
Thank you. Good afternoon. Could you please state your name for the record?
Garrett Brown,
And Mr. Burdine, how are you presently employed?
Jefferson County Sheriff's Office.
Are you a certified peace officer?
Yes,
How long have you been employed with the Jefferson County Sheriff's Office?
5 years.
And could you describe for the jury some of your duties in your present position at the Sheriff's Office?
Currently I'm a patrol sergeant for midnight shift patrol. Current duties are administrative, ensuring paperwork reports are timely, problem behavior of deputies, supervision.
Could you describe for the jury your educational background?
Educational, some college, things that I like to use in police academy. 4 years, Marine Corps as well, so some education background on that.
And was there any other training that you took besides the police academy and your military training that pertain to your duties as a sheriff's deputy?
Yeah, I've had significant amount of continued training.
Okay, can you describe that a little bit for the jury?
Sure. Well, I'm a police instructor, certified instructor, firearms instructor. I'm on SWAT, been through SWAT school. Several thousand hours of continued education, so
Were you employed as a sheriff's deputy with the Jefferson County Sheriff's Office on June 29th, 2019? What time did your shift start and end at that time?
we work from 6 p.m. to 6 a.m.
And what would your duties be on that shift?
Patrol and, answering calls, general duties of a police officer.
And on that night or early morning, were you in uniform?
Yes.
And were you in a marked patrol car?
Yes.
Your Honor, may I approach the witness?
Yes, you may.
I'm showing you what's marked as State's Exhibit Number 1. Do you recognize that?
Yes.
And what is it?
Shooting on video, body camera video. Yeah.
Okay, and have you watched and listened to that video?
Yes.
Was this recording on that disc prepared on a device capable of making an accurate recording of the audio and visual information?
Yes.
And at the time, was the operator competent to operate the device?
Yes.
And is the recording on that disc an accurate copy of the events that took place?
Yes.
Do the images of the event contained in that recording fairly and accurately reflect the event shown in the recording?
Yes.
Has that recording been altered in any manner?
No.
Would you be able to identify all the voices in the recording?
Yes.
And when was that recording made?
Not the incident, so it'd be, or morning rather, June 29th of 2019.
Your Honor, I'm tendering State's Exhibit 1 to the defense for inspection and offering into evidence.
No objection.
Okay. No objection. State's Exhibit Number 1 will be admitted.
Your Honor, I'd like to play this for the jury.
You'd like to publish? Yes, you may. Yes. Play the videos back. turn the lights off.
Robert, with your left hand, grab the door handle and open it slowly. Driver, if you can hear me, grab the door handle and open it very slowly with your left hand. I can only see one, but I can't see that back window. Can you see that back window? Barely, when we first rolled up, he did. Driver, let me see your hands. Jefferson County Sheriff's Office, driver, let me see your hands. And a driver and a passenger. Let me see your hands. Hey. Let me see both of your hands. Both of your hands right now. Let me see your other hand. Let me see your other hand. Let me see your hands. Let me see your hands. Let me see your right hand. Let me see it. Sheriff's office. Step out slowly. Come towards me. No, you're gonna step out right now. Step out. Step out, man. What'd you say? What'd you say? What is your name?
I'm Officer Buxton.
You got an ID on you? Hey, hold on. You got a gun in your car, bud? Hey, come out here and get your ID. You got a gun on you right now? Yeah. Hold on a second, though. This is one of them?
Yeah.
Can I grab it?
Yeah,
Everything's recorded. For orthopedic, not one. Hey, listen. All right. Come back here. What's your name now?
He fought me.
Yeah, see that.
I mean, we ain't got they were home.
Where you from?
We go to the house.
Where was it, huh?
They were,
You know where you're at?
yeah, that's where we were.
No,
When,
you're on the old side of Lake Road heading towards China.
when I was at the, so we were broke outside. I got still can't roll going. That's it. We talking about problem. Right here.
I'll take this real quick.
CL 122675150, Whiteville, last name Romero, first name Brian, middle name Keith, 112074.
He's Hey, you got one. You got your wallet on you, see? Just come to the front. Let me see your other guy. You got your one? Thanks.
you that, man, but it's good, man.
It just called.
Peace out. Okay?
What?
Yeah, right here.
I'm Lieutenant Bailey.
Yeah, listen, you probably look. Oh, let's see, man. Yeah.
It's not. It's not big brother. It's big brother. It's all it. Town detective. First one is a Texas CDL 11399789, date of birth 12/24/83, last name Buxton, Buxton, first name Clavon, Clevon. Next one, station driver's license 154000858, date of birth 3/10/81, last name Buxton Jr., first name Alton, Alton, both black males, Oklahoma. Well, we just had that.
It's probably not gonna want to do any problem on it for the city. One of them, a lot of the requests, let's see. Go with them now.
Yeah. Denise respond? Denise respond?
Yeah. Let's go take the passenger.
Hey, hey, you step back here, Lieutenant, back over towards that vehicle.
Hey,
Is it alarm or quick or, I say,
Put on EPO on PAP for this one.
how much you had drinks now, bro?
I was drunk earlier today, whatever. Look at this and that, whatever. I'm not gonna bullshit with you on bullshit. Just do what you want. Whatever you wanna do, you good. You want to check, you good.
You want to play the field sobriety test? None of it? Okay. You don't want to do the high staggers, walk and turn, one leg stand? Okay, you understand what all those are?
Yes.
Do you have any other weapons in that truck, or your car, other than the one, Springfield that I got? Okay, was there any ammo for it in there? It was unloaded.
Got it, you know, so
Okay. All right. Yeah, you know, I go to the, turn around, way down. Oh, clean it. Good. You see, all right. Keep going, guys.
I do not like the weapons. I don't.
The what, the weapons? I'm gonna put, 2 of them on, this one. This one, use your hand. Your hand, buddy. This car key. Oh, there it is. The door stuff. Okay. I'll leave this with your car.
I mean, I don't like me. You said you
I'm not different now. Turn around. Turn around.
I don't like.
I know, man. I know. Oh, hands up, right here. Hey.
If we get this word on the soon because of whatever, I don't like it, man. You gotta come out like I'm good.
Trying to do the best I can, dude. You got transport him, you got camera, I'm gonna transport him, and you can transport. You're not there, I have cameras. Never mind, go ahead, I'm serious. I'm gonna need to transport him, you have to need to transport him. Yeah, you can transport. I'll set you home.
No, man, I'm just saying that he don't like, I don't like it, man. Bro, hey, bro. Can I talk to him? On real, give it up. I just can't, man, give it that. I don't like this shit. I don't like this shit.
Let's do it.
You know what I gotta do, man? Let me that my ass.
Let's do it. Yeah, chill out. Do it again.
I'm trying to.
You don't stand up to the other officers here.
Adam, chill the fuck out. Al, chill the hell out, Al. Al, chill the hell out. Yeah, they're down. Hey, just them right here. I don't give a shit. I got it going on with this. I don't know. What the fuck it is, brother? That's your big brother? Yeah. Man, I'm not gonna make no arguments with what you do to me. Where's the last time, man? I ain't driving shit. Day. You never understand shit going on right now. I got this it what it is. I ain't, yeah, I think, no bullshit, man. I'm real shit. Hey, is that your department issue, pistol, or is that just your personal? Yeah, in there, I put up my side, this what? It's a Springfield. Is that your, that's mine, but that's, you don't carry it on, do you? I don't carry on, do it, but it's a determination. It is? Yeah. Okay. Man. Yeah, so you got eyes on it? Go. You cannot get through. You're gonna have to go around. You can't get through here, sir. You're gonna go down the meter and go around it. That takes free service. So, that's yours. Good. But I got to use yours car. So you got to get a car like that back down. I can carry it on it. I don't give a feel like a yes. But I say this. You got to deal with it. Listen, with me, you better deal with the point of me. Okay. Nope. You ain't gonna lean on that, man. That was hot. Yeah.
LZ, you wanna move this up so you can get these strapped through? Move it up front of your car. Hey, Denise, you want to transport him? And then digital cameras. Okay. And I'm gonna transport him. Okay. Man, you can wait 10 minutes. It'll be there. Him? Yeah. Yeah, good job. Follow me. Hey, follow me. You want to put him, you want. Yeah. All right, man. Yeah. All right, hey, listen. When you get in here, that's what I want you to do. When you get in, slide with your back against that other door, and lay your feet out this way. And you have plenty of room. I know, man. I can't. I know, man. I know, bro. Yes, sir. I got you. Go ahead. I'll look at it. Scoot straight back against that back door, like I'm sitting on the couch. Here, use that door, kick back. I can't put you in front, buddy. Here, look, listen. Put this leg up here. Put this one up here. All right. Now use that door. I'm gonna open this latch for you right here, okay? I'll turn some air on for you. All right? No, not at all. No, you been out, go there? What's up? You right there. Or look, that's my name. I'm you. Where's he at? Other side. There you go. That'll read you something. Yeah, get out real quick. No, just stay read it. No, stay back. Stay back against that door right there. There you go. You go right there. All right.
I'm gonna tell you, don't read it, I don't wanna read it.
You know, I got to read to you.
I don't want you to read it, just say, I don't, at the end of the day, you do, but.
Well, let me just stay here and read. You ain't gotta listen to the folks.
No, brother, go take a look, man, I don't.
I gotta do this, though.
Let me see what take, man, I don't, please.
I got to. You're under arrest for an offense arousing an acts alleged to be committed while you're operating motor vehicle on
I was not
or
ready.
while intoxicated, or an offense under section 106.041 alcohol beverage code. You'll be asked to give a specimen of your breath and or blood, so that you may analyze and determine the alcohol concentration, presence of controlled substance, drug, dangerous drug, or other substance in your body. If you refuse to give a specimen, that refusal may be admissible in subsequent prosecution. Your license, permit, or privilege to operate a motor vehicle will be suspended or denied for not less than 180 days, whether or not you're subsequently prosecuted for this offense. If you refuse to submit taking a specimen, the officer may apply for a warrant authorizing the specimen to be taken from you. If you're 21 years of age or older and submit to taking a specimen,
Can I step out real quick?
hold on. And an analysis of the specimen shows.
Can I step out?
No,
And stop, please, officer, if
you
at
can't.
the end of the day, you wanna take it, you gonna take it, whatever you gotta do,
You know,
but what I'm asking you is, can I step out?
no,
No, I'm asking you to step out, you what you wanna do, but I'm asking you to step out.
No.
Officer, whatever, because at the end of the day,
just hang tight, man. If you're 21 years or older and submit to the taking of a specimen, an analysis of the specimen shows that you have an alcohol concentration of 0.0 or you lost permanent privilege to operate motor vehicle.
Can I
For
see it?
not less than 90 days, whether or not you're subsequently prosecuted for this offense. Let me finish this. If you're younger than 21 years of age and have an detectable amount of alcohol in your system, what are you doing? Your license, permit, or privilege to operate a motor vehicle will be suspended or denied for not less than 60 days. However, if you submit to taking a specimen, analysis of your specimen shows you have an alcohol concentration of less than 0.08. Maybe sit back in the car. Sit back in the car. I think I know you. Don't make this stupid, dude. Don't make it stupid.
I'm sitting right there, man, you should. I'm going to go, man. We're gonna go there.
Girls in my car.
Hey, man, this your time.
Hey,
Get in the car, bro. I'm trying to take you, because you take my bro. Get in the car, man. I ain't giving a shit, man.
Listen, you gonna get in the car, we're gonna push you in the car.
Yeah, I'm gonna do what y'all gonna do. You gonna get in the car. I want to make sure my brother.
Your brother's all right.
Get in the car.
Bus, get in the car.
I'm ready to work. Your brother's in the other car. He's been transported to the jail just like you are. So get in the car.
Bus, I'm gonna pull you in that car, man. You know how this goes.
I didn't do shit, man. I ain't gonna go to ground. And I just come blind for shit.
Keep going back. Hey, dude, thank you. Hey, Denise, will you bring that clipboard? Bring that clipboard. That clipboard. No, it's on the end around. We just roll your back one down over here. Yeah, your driver's on there. Yeah. Okay. Yeah, roll your back one down. Can you hear me? Buster, can you hear me? You want me to finish reading this thing? If you're operating a motor vehicle and refuse to give a specimen, provide a specimen that shows you have an alcohol concentration of 0.0 or more, you get disqualified from driving a public motor vehicle for a period of not less than 1 year. You may request a hearing on suspension or denial. This request may be received at Texas Department of Public Safety's headquarters in Austin, Texas, no later than 15 days after you receive or presume to receive this. Yes, man. And the request to be made by written demand, fax, or other forms prescribed by the department. I certify that I have informed you both orally and in writing of the consequences of refusing to taking a specimen or providing a specimen. I have provided you with a complete and true copy of this statutory warning. I'm now requesting for a specimen of your blood. Do you consent to that? Buxton, do you consent to it? Okay, so. I got it in my car. Yeah. That's it. I left his key. That's it. Oh. I need to see it. Look.
Yeah, you. You take a picture of it? You remember the name of it?
I remember the name of it.
I just made
Yes.
for clarification on the record, the video was stopped at 5:12.
Okay, shall be noted.
When you were dispatched at 4:19 a.m. on June 29th, 2019, did you observe anything out of the ordinary?
Yeah, the vehicle stopped in the middle of the roadway. Actually, two driver's side tires were partially in the opposite lane of travel.
And what were the conditions like outside at that time?
Slightly foggy, it was dark. We actually received a phone call from dispatch on via private line, stating that a third-party caller called in dispatch stated the vehicle was out of place and something concerned them. It was the time of day, whatever the case was, they said they felt like somebody was trying to set us up for an ambush, which obviously.
Your Honor, I'm gonna object to hearsay.
Objection sustained.
I'll move on, Your Honor. When you pulled up, what type of car did you see?
It was a black Cadillac.
And is that a motor vehicle?
Yes.
Do you see the operator of that motor vehicle in the courtroom today?
Yes.
Would you be able to point that person out that you recognize as the operator of the motor vehicle, where they're sitting, and identify an article of clothing that he's wearing for the record?
Yes.
Can you please do so?
Yes, sir. And blue, but not sure.
Your Honor, may the record reflect that the witness has identified the defendant.
The record will so reflect.
And when you first observed the defendant's vehicle, what road was it on?
Old Sour Lake Road.
Is that a public place?
Yes.
And is that in Jefferson County, Texas?
Yes.
And how did you approach the vehicle?
I made a driver's side approach on my way with the passenger side.
Was the vehicle running when you approached?
Yes.
And how did you determine who was operating the motor vehicle?
By the station driver's license and it's 4 officers.
And what did you say to the operator of the vehicle?
Upon my approach,
Correct.
I asked him to show me his hands and then execute.
And how did the operator respond?
Very slowly. It actually took him several times. I made the announcement multiple times without any reaction at all. He was at the time unconscious when I approached him. When he came to his consciousness, he woke up and finally responded, argued getting out first before he finally exited.
Okay. And when you made contact with the operator of the vehicle, did you notice any smells?
Yeah, there was a smell of alcoholic beverage.
And what about his appearance? What did you see?
He was wearing a black Houston basketball t-shirt. His appearance appeared pretty kempt.
Did he have any slow movements?
It was very sluggish.
And what about the operator's speech? What did you hear?
Heavily slurred speech.
And how was the operator responding to questions that you were asking?
Questions were very, I guess, hazy, I guess at best. He responded in part, but it was very hard to understand. Most of the time, it took several times asking the questions to get the proper answer. In fact, he actually said he's working for law enforcement department. So that wasn't the case, obviously, as we know.
When you had the operator exit the vehicle, how were his movements once he stood up?
He was staggered, unsteady balance.
Did you ask the defendant to perform any field sobriety evaluations at the scene?
I didn't
And what was his response?
answer that.
Where was the key or the ignition key to the vehicle?
I don't recall. I'm assuming it was in the ignition. My lieutenant did a search of the vehicle, so
Is it possible that on the video it showed him having it on his person?
it may have, it might have been a button push or start push.
Were there other vehicles passing by normal traffic on that road?
Yeah, traffic was light, but
Would you say that it was a safety issue that the car was parked over the middle line?
absolutely.
In your opinion, was the operator of the motor vehicle intoxicated?
Yes.
And what information did you take into account to come to that conclusion?
His slurred speech, his unsteady balance, time and location where he was at, in the middle of the roadway. It's not common for someone to, a sober and prudent person to park in the middle of the roadway, and not knowing where they're at. So, wearing glassy eyes, smell of alcohol, beverage.
Okay. And did you read the required statutory warnings to the defendant?
I did.
And was the defendant willing to give his blood?
No.
What happens when a defendant refuses to give their blood?
We did a blood search warrant.
And so was a blood search warrant obtained that morning?
Yes,
And did you transfer the defendant to the jail?
I did not.
Why is that?
My rear cameras for my equipment system were malfunctioning.
Were you at the jail when the defendant arrived? And were you present when the defendant's blood was drawn?
I was.
And do you recall who drew the blood?
Miss Lynn, an RN from Jefferson County Jail.
And what was the defendant's demeanor at this point? Do you remember?
He was argumentative. Didn't want to go on blood draw. I advised him there was a warrant. Had the warrant in hand. He wanted to hold the warrant. I advised him he could not. He was very abrasive towards the nurse. Eventually, he did calm down. At first, he was very argumentative.
Okay, and can you tell the jury a little bit about what the standard procedure is for that type of blood draw?
So standard procedure, we would bring them back to the back of the jail, into the infirmary. The nurse would come in, they sit in a typical blood draw chairs you can see in any doctor's office. The nurse comes in, performs her duties, draws the blood, collect the sample, seal it back as evidence, take it to our evidence locker, and put it in the refrigerator, lock and seal for the next step, which would be to be sent off for testing.
And is that process, that standard procedure, what took place in this case?
Yes.
And so once the blood was drawn, did Ms. Lynn, the nurse, give the blood to you? Deputy, I'm showing you what's marked as State's Exhibit number 2. Do you
Yes,
recognize this?
Maxie, does he have any gloves on?
These are very good.
You need some large ones?
Yes, sir, yeah. I can see it from here, but, do I need to hold it, Judge?
If you don't, I'm saying if you're gonna touch it, you
Okay,
need
I can
to.
see it. I can
Okay.
see it.
Do you recognize it?
I do.
And what is it?
This is the blood draw submittal kit.
And how do you recognize that specific kit?
I actually recognize my handwriting and my name's on it, so.
And can you describe where your handwriting and name is on there?
Well, I'm sorry, that's not mine. That's actually, Captain Kelly's, but my name is here, and then,
Could
so
you,
we stop our filling unless there's any change of, possession, which would, so if I were to give the evidence to someone else for submittal, they would then go in and fill out this chain of possession portion at the bottom. However, since I took it, and my portion stops at the mark box of analysis.
okay. And let's talk about the seal on the box. Is your name on the seal?
Yes.
And did you place that seal there?
I did.
Your Honor, I'd like to tender this to the defense for inspection and offer into evidence.
No objection.
Okay, no objections. That states exhibit number 2.
And Deputy Verdon, has this been tampered with in any way?
Not to my knowledge.
I'll set this up here for now.
Okay, that's fine. Okay, stage 2 is entered.
And when you received the blood from Miss Lynn, where did you take it?
I took it to the Garrison County crime for evidence submittal.
And where did you leave it there?
In our refrigerator evidence locker, the one.
That's the witness, Your Honor.
Mr. Crenshaw, would you like to take a break at this time? It's been about an hour.
It's up to you, Judge. I can start, or if we want to take a short break.
Yes, let's take a short 5-minute break.
Won't be at the election.
That's fine.
And, is it
You can go
okay
get the
for
jury.
me- You know, I'm a rummer. Is it okay? for me
Okay.
to Move around. Thank you, Judge.
You may be seated. Let the record reflect that we're back in session and cause number 324160, State of Texas versus Clemon Demetrius Buxton. Mr. Buxton is here with his attorneys. The state is also present with Assistant District Attorney. And let the record reflect that the jury is also present in the courtroom. Ms. Maxey, you passed the witness.
That's correct, Your Honor.
Mr. Crisser, are you ready to proceed?
Yes, sir.
You may proceed.
Sergeant Verdine. First of all, thank you for being here today. This incident happened 2 years ago, thereabouts, correct?
Yes.
Are you testifying today to tell the jury that my client was operating the vehicle before you got to the scene or after you got to the scene?
Before I got to see.
And what evidence do you have that he was operating the vehicle before you got to the scene?
Well, I operated a vehicle on a public roadway where he was at with the vehicle belonging to him. Where he was sitting, the vehicle had to have been driven to that portion. And if you look at the definition of operating a motor vehicle, the fact that he was sitting behind the wheel of the vehicle running, whether in drive or park in the public roadway, is deemed the dense definition of operating. So.
Okay, and I appreciate you telling us what the definition is, but you understand the definition will be provided to the jury by the judge in the court's charge, and it's up to them to decide if the definition has been met. You completed a report in this case, correct?
Correct.
And in that report, says it's 6 pages, but I guess the first page was the PC and
Well, it goes into a general offense report and stuff.
Okay. But in the body of your report, and you prepared this right afterwards, correct? When your memory is most fresh?
Correct.
You said in the 4th paragraph that the vehicle appeared to be running.
Mm-hmm.
Appeared. You didn't say it was running. You said it appeared to be running. So what evidence that the vehicle was actually running do you have for this jury other than your assumption that the vehicle had been driven prior to you arriving there at the scene?
Well, the brake lights were on and there was exhaust smoke coming out of the muffler.
Sergeant, you're familiar with the operation of a 2014 Cadillac. The brake lights can be on regardless of whether the vehicle ignition is activated and the engine is running, correct?
That's true, but the engine running makes noise. I was heard.
But you didn't say in your report that the engine was running. You said it appeared to be running. So tell this jury what actual evidence you have that the engine was running.
Okay. There was a salt tongue from the engine on our approach. You can see smoke coming out of the exhaust tip. So.
Okay. Earlier, you stated that the key was in the ignition. And then you backtracked on that and said you weren't sure about the key, that maybe it was a fob. And then you backtracked on that and said you thought he had the fob on him. Where, in fact, was the key to the ignition?
Well, I think we established that it was in his pocket. Given the situation, I did say that it was, not exactly sure, but given the situation, I mean, where the key was at wasn't exactly my focus at that point. It was getting him out of the vehicle in the most safe manner possible.
True, but you told the jury earlier that in order to be operating a vehicle, the engine had to be running, correct? And I'm trying to be sure you in fact have the evidence to show the engine was running. You tried to act like earlier because the brake lights were on, that somehow meant the engine was on. An engine can be running and it can also be in auxiliary mode where the engine is not running. It may be making a noise and there's power inside the vehicle, such as the radio and the lights inside the vehicle. Is that not accurate?
I'm not sure if it's accurate with the 2014 Cadillac.
Okay. Well, let me ask you this. Was there a key or was there a fob?
I do not recall.
Don't you think something like that, again, this was 2 years ago, so I can't say that this just snuck up on me. 2 years ago, don't you think that because your definition of operating requires the vehicle to be running, that it would have been important to document things like that?
Sure.
But you didn't. If the key or the fob were in my client's pocket, you'd have that in the jail inventory of him, correct?
No, we leave the keys with the vehicle for the tow truck driver.
Okay. So what evidence then do you have that the key or the fob were in my client's pocket?
The video shot, I'm assuming it shows, I don't believe I remember pulling a key out of his pocket. So
You don't or do?
I do not recall pulling the key out of it.
I agree. I don't ever recall you pulling a key out of the pocket either, although that video is hard to see anything. It's a little easier to hear, but it's pretty dark. So under oath here today with something as important as this issue, you cannot tell this jury for certain that my client in fact had a key or a fob on his person.
No.
All right. Tell the jury, just in case somebody here, I know we all drive every day, but just in case we're all on the same page, what do you do when you operate a motor vehicle?
Well, typically, I mean, again, to sit behind the wheel of a vehicle that is capable of being operated, having the physical capacity to operate the vehicle is operating a vehicle. If I sit behind the wheel of my vehicle in my driveway, and turn the ignition on. I know we go back to that, we talked about earlier, that the ignition is on, and I have the capacity to operate the vehicle, I'm therefore operating.
That's your opinion?
No, that's a fact.
That's just a fact.
So, would you like me to provide a definition of physical control of a vehicle?
No.
Okay.
I just want to know when you operate a vehicle, what you do. And you're saying that all that's required is the engine is running per your definition.
And being behind the driver's seat.
And being behind the driver's seat.
Correct.
Earlier, you stated that we're here today and that it's your testimony to this jury that my client was operating the vehicle before you arrived at the scene. What actual evidence do you have for this jury that my client operated the vehicle prior to you arriving at the scene?
There's no evidence of him operating prior to me being there, but the assumption shows that when you get there and there's a guy passed out in the driver's seat with the other occupant being passed out in the passenger seat, so a reasonable and prudent person would believe that person that's in the driver's seat of that vehicle had just prior operated to that position on the roadway.
But again, you use the word assumption. So you want these 6 jurors to assume my client drove that vehicle to that position there on the street.
No, I want the jury to understand that reasonable suspicion points to the fact that he was operating that vehicle on public roadway prior to my arrival.
I am not here to debate reasonable suspicion, sir. But as you are well aware, reasonable suspicion is not what these 6 fine people have to decide my client's guilt on. It has to be beyond a doubt that's reasonable. And earlier you used the word assumption, okay? You have no actual evidence that my client operated that vehicle prior to your arrival, do you?
No.
All right. How many times during that video, and maybe there's one that I missed, did you hear my client say, I wasn't driving?
So,
I believe he said it at least 3 times. I heard it. 443 in State's Exhibit number 1, 446 in State's Exhibit 2, and at 507, I'm sorry, 446, 507, and 509. In your report, several pages, why don't you ever put in your report that my client said not once, not twice, but 3 times that he was not driving?
your client was extremely intoxicated, and I saw your client behind the wheel of the vehicle.
Well, but earlier you said that your testimony here today is based upon what my client did in operating the vehicle before you arrived at the scene.
I'm sorry, can you repeat that?
Earlier I asked you, are we here for you to testify that my client was operating the vehicle before you got to the scene or after? And you said before.
Sure, that's what the call nature was. So that's why I responded to the call. However, when I arrive on the call, now I see the guy and it becomes a current issue, not what we were called here for.
Okay, so would you like to now change your answer, and you're saying that you want the jury to convict my client of DWI because he was operating the vehicle after you arrived at the scene?
I think it's the totality of it. We got called there because he was operating the vehicle prior to our arrival. So we were told. We arrived on scene and I see him operating the vehicle.
Well, now you say you were told he was operating the vehicle prior to your arrival. How do you know that?
There was 2 males in a car operating the vehicle, whether, of course, we didn't know if it was him.
You don't know. So you keep saying these things thinking that, you want the jury to believe them as they're a fact, but you do not have, in fact, any evidence that my client was operating the vehicle prior to your arrival at the scene.
Yeah, that's true.
Your entire case is based on the assumption that he was.
My entire case is based on the fact that I, as a peace officer, saw a man behind a car that was running in the driver's seat of the vehicle.
Appeared to be running, and we're not even sure if he even had the key fob, correct?
True.
I hate to be difficult, but you do understand that I've got his entire career and life on the line.
I completely understand.
So we're clear, just because it seems like maybe there's been a little bit of confusion. Are you trying to tell the jury that my client was operating the vehicle that night before or after you arrived at the scene?
I know for a fact he was operating it after I arrived on the scene.
Okay, so now we're going to after. All right, so how long in fact did it take to wake him up?
Approximately a minute or so from the time of arrival. Exactly. I mean, given an approximate guess. From the time that I got out, started with my public address system to the time I approached and actually woke up, it's a minute.
Okay. Earlier you described him as being unconscious, but in fact he was just sleeping, right?
I'd be unconscious.
Okay. And so you just told the jury that when you arrived at the scene, he was operating the vehicle, right?
Correct.
Okay. So was he operating the vehicle while he was asleep or after you woke him up?
So would another question be, did he happen to just get in the vehicle that was in the middle of the roadway and fall asleep behind the wheel?
Objection, Your Honor. The witness is now asking me a question. So I would object to that as non-responsive and ask that the question he asked me be stricken from the record.
State your response.
No, you're.
Okay, objection sustained. At this time, ladies and gentlemen, jury will ask that his response be disregarded and it will be stricken from the record. You may proceed.
Thank you, Your Honor. Ms. Broussard, would you please read back my question, as I have lost my train of thought and forgot exactly what I asked?
Question, okay, so was he operating the vehicle while he was asleep or after you woke him up?
Thank you so much. What is your answer to that, sir? Was he operating the vehicle while he was asleep or after you woke him up?
Both.
Both. How does somebody operate a vehicle while they're asleep?
So he was behind the wheel of the vehicle again. His foot was obviously on the brake via the brake lights being on, or with the brake lights being on. So reasonable to believe that just because he's sleeping doesn't mean his foot can't move off the brake and slip to the gas pedal. We have no idea if the vehicle was in park or in drive at that point in time.
Officer, come on now, you're really gonna try to tell this jury that vehicle was in drive? Did that vehicle at any point lunge forward or make any movement at all at any time?
Nope, I said at the time when we arrived.
Okay, so your testimony before this jury is that someone can operate a vehicle in Texas while they're asleep.
Someone that has a motor vehicle running on a public roadway, absolutely. It's still a danger to the public.
In the 2 years since this arrest, have you done any follow-up investigation at all in this case? So you made some assumptions that night. You made your arrest and dropped it off to the hands of the jury to figure out, correct?
I don't think I made any assumptions. I think I made a pretty solid investigation, and then I dropped it off to the evidence lockers for the rest of the case to be investigated. And then went to the hands of capable attorneys and the jury.
Did you at any point in any of the times that he said he was not driving, ask him to clarify?
No.
You just kind of ignored that, didn't you?
No, I heard it, but there was no reason to clarify when somebody's behind the wheel of the vehicle. So at the end of the day, situation we ran into, what we're looking at, he's driving the vehicle.
So now you're telling the jury he was actually driving.
Operating the vehicle.
That's what it's.
Okay. Ms. Maxey, you may proceed.
Deputy Burdine. The defendant said that he wasn't driving. Is it possible that he said that because the car was parked?
It's possible.
And so he wasn't actually physically driving it at that moment? But he was operating the vehicle still. Is that correct? Did he ever mention how the vehicle mysteriously got there if he hadn't driven it?
No.
Or what mysterious person drove it there without him? No. And does a car emit exhaust when it's in auxiliary mode?
Not to my knowledge.
And so you mentioned that you saw exhaust coming out of the car, correct?
Correct.
And you heard the motor running?
Correct.
And you saw the lights on the car on?
Yes.
And, but the car wasn't on?
That's what I'm trying to be led to believe, so,
Was the car on?
yes.
Is it possible that just because there isn't direct evidence of operating a vehicle before your arrival, that the circumstantial evidence, the totality of all the circumstances taken in?
I'm gonna object to leading, Your Honor.
Objection sustained.
Do you need direct evidence to draw conclusions, or can you take into account other circumstances?
You can, of course, take into account the totality of circumstances.
And Deputy Burton, Mr. Crenshaw wanted to say that there was no evidence, right, that his client was operating the vehicle before you arrived, but there's actually plenty of evidence that.
Your Honor, I'm gonna object, that's leading.
Objection sustained.
You testified that there were lights running?
Yes.
And that the engine was running?
Correct.
And that you saw exhaust coming out of the car?
Yes.
And did that magically happen when you got to the scene?
No, it was like that when I was out.
Did the defendant ever say that he pushed the vehicle there?
No.
Did he run like the Flintstones?
Oh, shoot, no.
Let's go to 452 on the video. I'm fine.
Dude, what'd you say? What'd you say?
I walked the bomb.
What is your name?
I'm Officer Buster.
You got an ID on you?
Yeah, I do.
Hey, hold on a minute. You got,
Timestamp.
it's Corky. Oh, there it is. Yours too. I knew this was called. Huh?
I'm being I don't like me.
Deputy Burdine, did you find the car key on the defendant's person?
I'm sorry, ma'am, I was reading a portion of my report, I apologize. Did the video show that I did?
It did.
I'm sorry.
Can we watch it one more time?
Okay.
Dude, you said
It's Corky. Oh, there it is. It's yours too. I knew this was called. No. I don't like it. I'm being honest, I don't like me. Nigga,
Deputy Bird, did that refresh your memory at all?
Yes.
And did you find the key fob or the key to the vehicle on the defendant's person?
Yes, it's possible.
And would sitting behind the wheel of a car that's running with the key on your person be considered being in physical control of a vehicle? And being in physical control of a vehicle, is that considered operating a motor vehicle?
Your Honor, I'm going to object to
That's
leading, and she's also asking the officer to make a legal conclusion, and that's the job of the jury.
Objection sustained. Ms. Maxey, you may proceed.
Pass the witness.
Mr. Crenshaw, the witness is yours.
All right, officer, I'm sorry, Sergeant. You testified at first that you assumed the key was in the ignition, right?
I guess I didn't really recall, but
Okay.
we're guessing around the,
Okay.
where is that?
Okay, and now there was a key or a fob, whatever it may be, that you said that you found in the pocket.
Sure.
Okay. So, just so we're clear, your testimony then is simply because he was after you arrived at the scene, even though he was asleep and you later woke him up, that he was in fact DWI because he was operating a vehicle that you claim was running.
Because he was operating on a vehicle on public roadway.
Okay, I'll give you the roadway. I'm not here
Yeah,
to
and
dispute the roadway. Okay. And so now your evidence of that is because he had the fob in his pocket and because the lights were on and you said you saw exhaust?
Yes.
Is there a reason why then if you saw all these things that made it so clear to you that you didn't mention them in your report?
No, but if you look at my report, the paragraph you're mentioning where I say appeared, that's also, we hadn't verified whether or not it was running at that point in time. If you, again.
Sergeant, you made this report well after you arrested my client.
Sure I did. As we approached the vehicle, it appeared to be running. At that point in time, this is based on observation. Maybe I should have clarified later that the vehicle was in fact running, but I didn't. At this point in my report, I'm stating what's happening at that point in time.
Right. And so, but just so we're clear then, you saw the lights on, which we can clearly see in the video.
Right.
And it's your testimony that the engine was actually running.
Correct. And you can actually hear that in the video as well.
Oh, you can hear the Cadillac engine in the video?
I could hear it when she played the first portion of that
Okay.
when we were talking to him.
Okay. But you also are operating under the assumption that the jury is going to believe that someone asleep behind a wheel is in fact operating that vehicle.
Their state of consciousness doesn't play a factor in whether or not they're behind the wheel and operating a motor vehicle. If he got there, so just because you fall asleep behind a motor vehicle does not deteriorate the fact that you were operating that motor vehicle. He's still in physical control of that vehicle.
Well, physical control is more possession, right?
Sure, but he's in possession. He's in the driver's seat where he can access the start and stop, the ignition, he can access the gear shifting.
But you have absolutely no evidence that he ever attempted to put the vehicle into gear or the vehicle was actually in gear. There's nothing about when you try to pull him out that you had to go in the vehicle and turn the engine off or put it into park. None of that, right?
There's also nothing that says the vehicle has to be in drive in order
What's
to
that?
operate it. There's nothing that says the vehicle has to be in drive to operate it. Simply stated. I mean, if he got there, someone had to have driven that vehicle, with him being by the driver's seat.
But you don't know who.
Not before I got there.
You asked him a lot of questions while I was out there that night. I mean, we watched that video, went on for 20, 30 minutes, whatever it was. These are important things, right? To complete in a DWI investigation, i.e. how did the vehicle get here? You never once asked that question, do you? So you just assumed he's the one that brought the vehicle here, and you just assumed because he was behind the wheel that he was the original driver, and you now want to make him guilty of this offense because of that assumption.
Yeah, that's pretty much what we need. I mean, you need a guy behind the wheel.
That's what you need in order to make an arrest, correct?
Yes.
But to convict someone and say that in fact, beyond a reasonable doubt, they are the operator of the vehicle at that time, you have nothing that shows that my client did anything when you arrived at the scene other than sleep and be drug out of the vehicle.
So the fact that he's sleeping behind the wheel of a running vehicle, just so that I understand, so I can clarify, I just want to know that, are you asking me if I think that is probable cause, or that's enough evidence to prove that he's operating the vehicle?
You made that decision right then that you had probable cause to arrest him, correct? Yes. Right. Because you think just because someone's sitting behind a vehicle and it may be running, that you in fact can arrest them for DWI.
Yeah, on a public roadway, absolutely. In a public place where I have.
And you made an example earlier of if you go in your driveway and sit in your car. So you're telling me that the law is in Texas that if I'm in my house and I have a few drinks and I go outside and I sit in my car to listen to music and it's hot outside, so I turn the engine on, so the engine's running and the AC's on, then I'm DWI.
No, I made that as a reference to.
Yeah.
What's your objection?
The objection is that the jury is finder of fact, and Mr. Crenshaw is wanting to debate what the law is, and that's not.
Your Honor, Mr. Crenshaw is asking the officer here to tell the jury what the law is on this, and he's already objected to that earlier, that the officer would not testify as to what the law is on this.
Okay, well, I'll sustain that portion of objection, but let me do this. I know we have first and the second chair, but only one person need to make the objection.
I understood, Judge, but I'm giving a little leeway.
Okay, Mr. Crenshaw, you may proceed.
All right. Earlier, your testimony, you gave me an example of people that you, in particular, would go out and sit in your car with the engine running, and you said that was operating. Okay. And so your testimony then to this jury, that if I'm in my home and I have a few drinks and I get intoxicated and I decide I want to go sit outside in my car with the AC on and listen to the radio, that I'm DWI.
Frankly, if you have immediate access to a public roadway, you definitely could be DWI.
And other than my client, have you ever arrested someone in that circumstance?
In what circumstance?
Sitting in their driveway, listening to music that's had a few drinks and you arrested for DWI?
Not a driveway, but there has been public place.
So their car's parked in front of their house on the street.
It's called a jack in the box.
And you-
It's happened.
And you've made arrests for that?
That's correct.
Someone DWI?
Yes.
Okay.
Ms. Maxey?
Did you have an assumption that the defendant was operating the motor vehicle, or were you able to come to that conclusion through your investigation?
I came to a conclusion which led to probable cause.
It wasn't just an assumption, right?
Correct.
Nothing further, Your Honor.
very brief,
Okay.
Judge. And just so we're clear, so we're all on the same page here, it's your testimony that my client was operating the vehicle before or after you got to the scene that day.
Objection, Your Honor, ask and answer.
This is the first question on cross.
Okay. Objection overruled. You may proceed.
Your testimony to this jury is the client was operating the vehicle before or after you arrived at the scene?
After.
After. So your testimony is he was operating the vehicle while he was asleep or after you woke him up?
Both.
Both. Thank you.
Ms. Maxey, you have any questions?
Nothing further, Your Honor.
Okay. Mr. Crenshaw. Okay. Officer Burlane, you'll be excused. You're subject to being recalled for additional questions. The court must inform you that the rule has been invoked and you are ordered to leave the courtroom and not re-enter unless instructed to do so by the bailiff or me. You are not to discuss this case or your testimony with other witnesses or anyone else except the attorneys. You are not to read any report of, comment on the testimony or evidence in this case. Any witness violating this instruction is subject to being held in contempt of court. Do you understand? Okay, you may step down. You're excused. Okay. State, you may call your next witness.
Your Honor, the state calls Lieutenant Robert Bailey to the stand.
Robert Bailey, okay. Mr. Bailey, you can come forward. You stand in front of the court reporter and raise your right hand. She will swear you in.
Do you solemnly swear that the testimony you give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Lieutenant Bailey, you may take your seat and you can adjust the mic and chair. Ms. Maxey, you may proceed.
Thank you, Your Honor. Good afternoon.
Yeah, man.
Could you please state your name for the record?
Robert Bailey.
And what is your, or how are you presently employed?
I'm a lieutenant on the patrol division of the sheriff's office.
And are you a certified peace officer?
I am.
How long have you been a peace officer with the Jefferson County Sheriff's Office?
For this agency, 14 years.
And what are your duties in your present position in the Sheriff's Office?
I am the one of the night shift commanders. I supervise a sergeant and several deputies. I'm, I guess you'd say, the administrator for the night shift.
Can you describe your educational background for the jury?
I've got some college. I originally went to school for nursing. That worked over too well. I went to the police academy in 1995. Been doing police work ever since. So I've got that many years of experience. I've been with this agency for 14 years. Been with Hardin County for about just shy of 14 years, and also worked in Hill Country for another sheriff's office for a few years.
During your time and throughout your training, have you had any training geared towards detecting the signs of intoxication?
Yes, ma'am.
And Can you describe that a little bit for the jury,
Signs of intoxication.
or what the extent of that training?
It's been several years. I had the SFST, the Standard Field Sobriety Training, it's been years ago. Since I have promoted, I have not dealt with too many DWIs since I haven't supervised, but I've made numerous DWI arrests. It's been a long time since I've gone to SFST training.
Were you employed as, at the Jefferson County Sheriff's Office on June 29th, 2019?
Yes, I was.
And what time would your shift have started and ended?
6 p.m. to 6 a.m.
And what were your duties on that shift?
I was the only supervisor working that night, so I had to make myself available as a backup officer if anybody needed it. So I was actually out in the field that night, not stuck in the office.
Were you in uniform that night?
I was.
Were you in a marked patrol car?
I am.
Your Honor, may I approach?
Yes, you may.
I'm handing you what is marked as State's Exhibit number 3.
Mr. Make sure that he has his gloves on if he's gonna handle that.
Okay. Do you recognize it?
Yes.
And can you tell us what it is?
Appears to be a DVD copy of my body camera from the night of that stop.
Okay, and have you listened to and watched that recording?
Yes, I have.
And was that recording prepared on a device capable of making an accurate recording of audio and visual information?
Yes.
Was the operator competent to operate the device?
Oh, yes, ma'am.
And is the recording an accurate copy of the events that took place?
Yes, and that's how I dictate my reports at the end of my shift. I use the copy of my video.
Okay. Do the images of the event contained in the recording fairly and accurately reflect the event shown in the recording?
Yes, ma'am.
And has that recording been altered in any way?
Not what's come out of my hands. It doesn't appear to be.
Okay. And would you be able to identify all the voices in
Yes,
the
ma'am.
recording? Okay. And when was that recording made?
June 29th of 2019.
Your Honor, I'm tendering the exhibit to the defense for inspection and would like to publish to the jury.
May we approach, Judge?
Yes, you may. Stand on that side so she can hear you.
My objection to this video, Judge, is that he was with the passenger the entire time, this officer, and the majority of the communications that are captured on this exhibit are communications between the passenger and this officer. Therefore, they would be hearsay. The statements on the other video that were coming in were of my client, which, that's a statement against interest. But this is a conversation he had with the passenger, and I don't see how that's relevant so far as this case, and it's hearsay because it's out of court statements.
Okay. State, did you hear what he?
Your Honor, this recording also has a lot of evidence that is relevant to this case. And I'm willing to stop the video before he's with the brother.
Oh, that's fine.
Okay, so
Yeah, as long as there's.
do
not
y'all
going-
know where it
I
starts?
don't, but as long as there's not going to be any statements of the brother. I got no problem.
I can stop it before the brother is.
Okay, okay, so we'll,
So with that understanding, I'll withdraw my.
okay.
Hey. See both of your hands. Both of your hands right now. Let me see your other hand. Let me see your other hand. Let me see your hand. Let me see your hand. Let me see your right hand. Let me see it. Sheriff's office.
How long, man? Pastor, don't move. Hold on, man. You have any idea where you're at? Yeah. Where you at? You're a long way from Port Arthur. No, don't reach in your pockets. That's what I'm saying. Don't reach in your pockets. I can do that shit, whatever. Mm-hmm. Do this shit, whatever. Getting songs off. Pull it out. Hold that traffic. 7150 White Mill, last name Romero, first name Brian. Huh? Hold on, man. Hold on now. All units hold their traffic until further advised. We have driver. We haven't checked the passenger yet. Yeah.
Lieutenant Bailey, when you were dispatched at 4:19 a.m. on June 29th, 2019, did you observe anything out of the ordinary?
When I arrived at this scene,
And what did you see?
a blue Cadillac straddling the middle of the road at a dead stop.
And you said it was a blue Cadillac. Is that a motor vehicle?
Yes,
And do you see the operator of that motor vehicle in the courtroom today?
yes, ma'am.
Would you point to where the person you recognized as the operator is sitting and identify an article of clothing that he's wearing for the record?
The gentleman at the very far end of the defense counsel table in the, looks like a dark blue button up shirt.
Your Honor, may the record reflect that the witness has identified the defendant.
The record will so reflect.
When you first observed the defendant's vehicle, what road was it on?
Old Sour Lake Road.
Is that a public place?
Yes, ma'am.
Is that in Jefferson County, Texas?
Yes, it is.
And how did you approach the vehicle?
In a, what we call a tactical approach for officer safety based on information we received from the dispatcher.
And was the vehicle running when you approached?
Yes, ma'am, it was.
And what clues did you have that the vehicle was running?
You can hear the, once we got out of our patrol vehicles, you could hear the engine of that vehicle running and also the headlights running.
Did you have any interactions with the operator of that vehicle?
Not until he was already out of the vehicle, standing outside into the rear.
Okay, and when you, when he was standing outside, did you catch any sort of smell that caught your attention?
Oh, yes, ma'am.
And what was that?
What we commonly refer to as the odor of alcoholic beverage.
Okay. And what about his appearance and movements? What did you notice about
Oh, yes,
that?
ma'am, is very sluggish and awkward, intoxicating gait, as we commonly refer to. And of course, a very strong smell of alcoholic beverage. His eyes were extremely glassy and bloodshot. And as we could tell, you have a hard time understanding what he would talk.
So, so the operators, describe the operator's speech, I'm sorry.
Extremely sluggish and unintelligible. I couldn't hardly make out what he was saying at the time.
Did he at one point mention to you something about getting in his car and going?
He asked me if he can get his car and just leave.
How was the operator responding to any questions that were being asked?
I didn't have much interaction as far as questioning him, except asking if he knew where he was at.
In your opinion, was the operator of the vehicle intoxicated?
Yes, ma'am.
And what information did you take into account to come to that conclusion?
Based on the signs I just mentioned about his, the way he was talking to us, the very strong odor of alcohol beverage about his person, the way he was walking, that's on the vehicle, and he also had to lean on his vehicle for support to keep him falling to the ground.
Pass the witness, Your Honor.
Mr. Crenshaw, you may proceed.
Thank you, Your Honor. Lieutenant Bailey, my client was drunk that night, wasn't he?
I had reason to believe so, yes, sir.
I agree. How many times have you testified in DWI trials before?
The interview trials is probably my third time.
Third, in any of your prior trials, has the defense attorney ever conceded that his client was intoxicated on the night in question?
Yes, sir, each time I have.
Well, good. So here we are. I apologize, first of all, for my client's actions that night. Okay, he had way too much to drink. All right. But this jury has a decision to decide beyond a reasonable doubt whether or not my client was in fact driving while intoxicated that night, right? In your report, you refer to my client, I can't even count how many times, as the driver, correct?
Correct.
But today, my client is the operator. Why didn't you refer to him as the operator in your report?
Well, to be honest with Mr. Crenshaw, there is a definition in the Texas Administrative Code that explains what a driver is. It's not necessarily just somebody who's driving the vehicle, but also in physical control of the vehicle.
Okay, okay. And so then you're operating on a definition then that the person in control of the vehicle is the operator.
No, sir, who's the driver? The definition in administrative code is the driver.
Okay.
That's who's in physical custody.
Okay. Well, you understand that this jury will not get that definition that you're referring to. Okay. So let me ask you this. Is your testimony here today that my client was operating the vehicle before you got to the scene or after you were at the scene?
When I got to the scene, he was the occupant behind the driver's steering wheel.
Well, okay. So he's the occupant now behind the driver's steering wheel.
It's semantics, Mr. Crenshaw, but he was in the vehicle behind the steering wheel of a running vehicle that was parked in the middle of the road.
Right, I get that, okay? And so I guess I'll go back to my original question. It's your testimony here today that my client was operating the vehicle before you got to the scene or after?
Yes, sir, I believe.
After or before?
Before.
Well, now I'm confused.
He was before he got there, or before we got there, it is my reason to believe that he was also occupying that seat prior to our arrival.
Okay, so now you're DWI, you occupy the driver's seat.
Excuse me, what was that?
I'm just trying to clarify what you said. So is it your testimony before the jury that someone is driving while intoxicated if they're intoxicated while they occupy the driver's seat of a vehicle?
If they're parked on a public roadway, that's my reasonable belief that occurred.
And all it requires is occupation of the driver's
He's
seat.
in physical control of the vehicle.
Okay, so now we're back at control. All right. And so you don't have any evidence at all that my client was driving or operating that Cadillac that night before you got to the scene?
Before I got to the scene, that's correct, no.
You're just assuming, and you want the jury to assume he was the driver.
Yes.
You heard my client, a lot of what he said you couldn't really understand, right?
Correct.
Let me ask you this. When you operate a vehicle, what do you do? Just give us a brief description of what you do when you operate a vehicle.
As an operating and a moving motion on a public roadway, or
To
sitting?
you, when you operate a motor vehicle, how do you do it?
I sit behind the driver's seat, I engage the ignition, I operate the gears by whatever gear shift is available to me. I accelerate gas, I apply a brake. When I come to a stop, I can put it in park, take my foot off the brake and off the gas pedal and rest comfortably wherever I'm at, as long as it's in park.
Lieutenant Bailey, you and I are in complete agreement about what you just said about how you operate a vehicle. Thank you for clarifying that, sir. But you never saw my client put this vehicle into gear, did you?
I did not.
You never saw my client turn the engine on or turn the engine off.
Correct.
You, in your report, put that the engine appeared to be running, and now you're saying you could hear the engine running. But regardless, other than the fact that the engine was running and he was behind the steering wheel, your example earlier about what you need when you operate, none of that existed, did it? You have no evidence at all that he ever used the pedals, that he ever shifted the gear, that he did anything other than sit behind the wheel. Okay, thank you. And just so we're clear, is it your testimony that he operated the vehicle, by your definition, while he was asleep or after y'all woke him up?
Well, sir, there's a definition, in my opinion, there's the difference between sleeping and passed out.
Either way, whether he's sleeping or passed out, I'll give it to you either way. The previous witness called him unconscious. Either way, sleeping, passed out. Is your testimony here today that my client was operating the vehicle while he was passed out / sleeping / unconscious, or after you woke him up?
Even after we woke him up, he wasn't even operating. He was sitting behind the steering wheel, so he was in a stop motion, asleep, passed out, unconscious behind the steering wheel of a running vehicle.
Okay. So you just said when, after you woke him up, he was not operating the vehicle.
Again, Mr. Crenshaw, we're going with the semantics here.
Well, what you call semantics, sir, I call a man on trial for his career and his life, sir. I'm
understand that,
sorry.
But I've been a police officer for many years. I take the totality of what I see when I arrive on scene.
Okay, well, all I want you to do is just please tell
And I'm
me,
telling
six
you, we were
ladies and gentlemen,
dispatched.
or was he operating that vehicle while he was asleep, passed out, unconscious, or after you woke him up? Which ones?
Was he operating actively? No. Was he physical control of that vehicle? Yes. I mean,
I'll give you that. He was in physical control of the vehicle. Thanks.
Well, hold on. Mr. Crenshaw, you pass witness? I just saw you said.
Yes, Your Honor, I do pass the witness.
Okay.
I was excited.
Ms. Maxey, witness is yours.
Thank you, Your Honor. Lieutenant Bailey, is it possible that you called the defendant the driver in your report because the charge is called driving while intoxicated?
and that's the common terminology we use.
And is it possible that the defendant operated the vehicle not necessarily before or after you got there, but during your time there on the scene?
Like I was Mr. Crenshaw, if he's behind the wheel and he's in control of that vehicle in the middle of the roadway while it's running, yes, he is the operator / driver.
And do you need direct evidence to draw the conclusion that the defendant was operating the vehicle, or can you take into account circumstantial evidence in the circumstances?
I'm going to object, Your Honor, to that question. It's kind of calling for a legal conclusion from the witness.
Objection overruled. You may proceed.
Do you mind repeating that?
Sure. Do you need direct evidence to determine if someone is operating a vehicle, or can you use the circumstances surrounding when you're on the scene to draw that conclusion?
Based on my observations and what I observed at the scene at the time, that's how I based my conclusion, my decision.
And when someone is operating a vehicle, are they required to put the car in drive in order to be operating it?
No, ma'am, they're not.
Okay. Did the defendant ever say who was driving the vehicle? Did he ever say it was someone other than himself?
I can't recall directly right offhand without looking at my report.
Did he ever mention how the car got to the middle of Old Sour Lake Road in the middle of the night?
Again, if I can look at my report real quick, something was said. I remember him saying something about his brother, but I don't remember exactly what point of our conversation that was said.
Did someone have to operate the vehicle in order for it to get to where it was?
Somebody had to.
Pass the witness.
Mr. Crenshaw?
Yes, Your
Witness
Honor.
is yours.
I'll be brief. Lieutenant Bailey, I will completely 100% concede and agree with you. Someone had to operate that vehicle to get it in the middle of Old Sour Lake Road. But you have absolutely no evidence whatsoever that it was my client, do you?
Not separate based on what I said earlier.
Not separate, other than what you observed after you arrived there at the scene. Do you? You would agree with me that your entire case is built upon the idea that you and Officer, what was the other officer's name? Verdine? Sergeant Verdine assumed my client is the one that drove that vehicle to that area where you found it, correct?
based solely on my observation.
Right. And that's just your assumption, and you're hoping that the jury assumes that.
I want the jury to use their own mind based on what they saw when we hear.
But it really, to you, doesn't matter who drove it there, right? Even though you hope that they think that it was him, because in your opinion, my client operated the vehicle after you arrived at the scene. So it doesn't really matter what happened before, does it?
I can't assume what happened before. I can only go by what I observed.
Right, but you do assume that he drove to get the vehicle there. I mean, she just asked you, you know, how
Yeah,
did that
I
vehicle
can
get?
I can only assume based on what I saw when I got there.
And it was your decision, because you were the top guy there at the scene, right? It was your decision to arrest my client for DWI.
I told Sergeant Purdine, we gotta do.
Right, and you explained that in your report by saying that that meant that you had to arrest him for DWI.
Mhm.
And you arrested his brother for PI.
Correct.
And you could have arrested my client for PI as well, couldn't you?
That's not a lesser included offense, sir, for DWI.
Well, I don't know that, but you could have arrested him for PI though, right?
I wouldn't have, no, sir.
You wouldn't have?
No, sir.
Okay. And is it also your testimony, like it was Officer Verdine's testimony, that if someone's in their house and has a few drinks and decides to go out and sit in their car that's parked on the street and
I'm not
start the
gonna
engine and listen?
This is a hypothetical.
That's not a legal objection.
Objection overruled.
Is it your testimony that if someone has a few drinks in their own home and decides to go sit out in their car that happens to be parked on a street and turn the engine on and listen to the radio, sitting there minding their business, that they are DWI in the state of Texas?
Yes. If they're parked on public street, yes.
And you arrested people for that?
I have not, no. You asked me a question, how I felt about it, and I'm telling you that's what I.
So you say it makes a legal definition, but never before in your career. How long have you been an officer?
Since 1995.
Since 1995. You've never arrested somebody with that set of facts, have you?
Not that set of facts.
Because it doesn't really sound reasonable, does it?
I've never had the opportunity yet.
So you would like to arrest someone for that?
I would have liked to, but if I was put in that situation, I would.
You would. You're going to jail for DWI for sitting in your car, listening to the radio, minding your own business if it's parked in a street in front of your house.
With the engine running.
With the engine running?
Yes.
You ever go to Crystal Beach?
Choose not to, but I have.
It can sometimes be challenging, I understand.
Nasty beach.
Yes. Well, yeah, I'll pass it on.
Ms. Maxey?
Lieutenant Bailey, was the car in this case parked on a driveway?
No, ma'am.
Was it parked on a public road?
It was.
Was it parked in a single lane of a public road?
It was straddling the yellow striping.
It was in the middle of the road?
Yes, ma'am.
Was there any traffic going around?
No, ma'am, that's interesting you brought that up. That is a heavily traveled roadway in the morning. It was just before, at the end of our traffic stop, you start seeing the traffic start increasing. So we got there just in time for the work traffic.
So is it safe for somebody to be parked in the middle of a public roadway?
Not in that fashion, no, ma'am.
Fascinating.
Mr. Crenshaw?
No further questions.
Okay. May this witness be excused?
Yes, Your Honor.
Okay. Lieutenant Bailey, let me remind you that the rule has been invoked and that you are ordered to leave the courtroom and not return unless instructed to do so by the bailiff or me. You are not to discuss this case or your testimony with any other witnesses or anyone else except the attorneys. You are not to read any report of or comment on the testimony or evidence in this case. Any witness violating this instruction is subject to being held in contempt of court. Do you understand?
Yes, sir.
Okay, you may be excused.
He's subject to recall, Your Honor.
Yes.
Thank you.
Yeah, I'm gonna ask that.
Okay, ladies and gentlemen, jury, at this time, we're gonna take a 10-minute break. And ladies and gentlemen of the jury, if you like some water, some coffee, just let us know. We have some prepared in the back, and you can also use the restroom if you need to use the restroom. Okay, just follow the bill. I need to see the attorneys up here. Ms. Max, I just need to know, you have another witness?
Yes, Your Honor.
Okay, we have an idea how long it may.
The next few will be short.
Oh, well, I have good news. So are you doing the third officer?
I am.
Okay, so I think that will be brief. And then I anticipate stipulating to the blood. So that will save the testimony of the nurse and the toxicologist. And
Okay,
so,
well, I'll let them think about that, whether or not they would still want to go forward or let you stipulate.
And if, well, I'll let them go.
well, I mean,
Okay.
I've been mentioning this to him for several days.
Oh, okay.
I mean, I'm stipulating to intoxication and the BAC, so. I
Okay,
imagine.
well, what we'll do, well, like I said, we'll be on a 10-minute break, and
Okay.
then we'll come back.
I'm just gonna read these in the record and-
You're gonna offer it, just read it. Yeah. Okay, you may be seated. Let the record reflect that we're back in session at cause number 324160. The case is styled the state of Texas versus Cleavon Demetrius Buxton. We have Mr. Buxton in court with his attorneys, and we also have present the state assistant district attorneys. And let the record also reflect that the jury is present in the courtroom. At this time, state, you like to proceed?
Yes, Your Honor. The state has a motion for stipulation, and the state requests to read it into the record.
You have any objections, Mr. Crenshaw?
No.
Okay, you may proceed.
Comes now the state of Texas and the defendant through their respective attorneys and agrees that the defendant's blood and any test results are deemed legally admissible for the purposes of this trial. Defendant stipulates to State's Exhibit 4, the laboratory toxicology report showing the defendant's BAC to be 0.230 grams of alcohol per 100 milliliters of blood. Defendant stipulates that he was intoxicated in accordance with the definition of intoxication under Texas Penal Code, Section 49.04, subsection D. Additionally, both parties waive any objections that otherwise could be raised, including but not limited to hearsay and/or improper foundation. Respectfully submitted. The state moves that this be offered into evidence.
Mr. Crenshaw, you have any objections?
No objection, Your Honor.
Okay, no objection. State's Exhibit 4 will be admitted into evidence. Ms. Maxey, state has any other witnesses?
The state rests, Your Honor.
Defense?
The defense will put on its case, and we would ask that we break for the day and begin that tomorrow.
Okay. Ladies and gentlemen of the jury, the state has rested its case. And so this will end the trial for the day. However, we will need you back on tomorrow at 1 p.m. So at this time, you are excused. Make sure that you have your badges and follow the bailiff.
I just have a brief motion, Judge.
Okay.
I would make a motion for a directed verdict in this case, Judge, based upon the evidence so far. It is the defense's position that the state has failed to meet the element of operating.
Okay, that motion will be denied. Okay, we'll see everyone back tomorrow at 1 o'clock.
Thank you, Judge.
Thank you.
You're welcome. We'll be in recess.